What is the most important decision in estate planning? I received that question. It's very difficult to answer. Not because I don't know, but it sort of is like asking, what is the most important thing in comedy? What is the most important thing in love? What is the most important thing in raising children? What is the most important thing in buying a house? Depends. DEPENDS. I'm not speaking about the diapers. The circumstances of what is the most important decision. At its base level, it would be, should I have a plan or should I not have it? Does he love me? Does he love me? Probably is really the base question. I believe everyone needs a plan, whether you have small assets or large assets, because you want to direct for the benefit of your loved ones, the people closest to you, where your assets go when you pass away. If you don't have a plan, then you are stuck with the plan that your state gives to you. So in New York, there's a different distribution plan for every person depending on their situation. A single person has a certain distribution structure. A married person with no children has a plan in place. A married person with children has a plan in place. The government does have a plan if you have immediately close blood relatives. So a single person with a committed partner won't have the benefit of the married person plan. So even if you're with this partner for some really long time, 30 years, 27 years, 54 years, if you're with that person will not naturally inherit from you if you're single, if you've never been married. That seems like a shame. So in that scenario, the most important decision in estate planning is whether to have a plan or not. If you're married with children, well, your children are provided for, and it comes out of your spouse's share. So if you have a committed married partner, you're together, you're in it together, you want to be together, you've gotten that piece of paper and the ring, well, I'm sure people want to plan for their children, but do you want to plan for your children to the detriment of your spouse? And that, in fact, might be. So the depends comes up a lot in the law. Really, issues related to estate planning are fact-specific, individual person's family dynamic specific. My opinion and my prescription for you from Dr. Frank, you need a plan. Oh, and I'm in that scenario, I'm the pharmacist.
I can't find the will. I can't find it. I don't know where it is. I believe there was a will. I was told there was a will. I thought there was a will. I can't find the will. You have an issue. There's a deep issue if you cannot find the will. The law has the presumption that if you can't locate the original will, that the person that made the will ripped it up. The person that made the will destroyed the will. The person that made the will threw out the will, right? It makes sense. If you can't find the original, well, then it doesn't exist. That's the presumption. A will in New York State is not required to be filed anywhere. You don't have when you make it. So today, let me give you a scenario. If today I make a will, that will should go into a safe place. It should go into my sock drawer, or it should go into my cabinet, right, the file cabinet, or it should go into that accordion folder with my other important documents, or it should go into my home safe, or a fireproof box. That last will and testament should go with my other important documents. If you have the availability to put it into something that is fireproof and waterproof, put it into there. Some people use a safe deposit box. I don't necessarily recommend that, but place it somewhere safe, because your family member, your executor, your loved one, your person has to produce the original will at the time of your death, and then and only then is it required that it be filed with the court. And in New York, that's the surrogate's court. The original will must be produced. If you cannot produce the original will, the thought, the belief, the presumption is that you must have thrown it away. You must have revoked it. You must have ripped it up. I didn't make up that. That's what the law says. That's the thought that the law, capital L, capital A, capital W, the law says. Right? Makes sense. If I make a will now and I say everything will go to this person, and then later on I change my mind, well, all I have to do is rip up that will or revoke it or make a new will. That person may have a copy of the will when I gave them everything, but then 3 months later or 3 months later or 30 years later, I decided to change my mind. I said, no, that person and I are far and away. We're on the outs. We're not getting along. I don't want that person to have all of my assets. I am no longer providing for that person. And there is no place to make that declaration. Right? There is no document in the law that I'm aware of that says I am not going to give my assets to this person. The only place to do that is inside of a will. So if you have a will and you want to change your mind, get rid of it. Revoke it. Make a new will. But the start of this is, I can't find the will. That's what happens maybe once a week. Someone will call me and say, we can't find the will. I don't know where the will is. I believe there's a will. My mother had a will. My father had a will. I don't know where it is. My sister, my brother may have destroyed it. Well, if you cannot locate it, it does not exist. It's not what you think. It's what you can prove. It's not what you were told. It's what actually now exists. When you make a will, please keep it in a safe place. The copy is good, but the copy is not legally sufficient. Place the original in a location that is retrievable. But if we look at it from the other angle, the person that wants to produce the will, because they were the chief beneficiary of that will, well, if they don't have the original, it might be because the will maker at some point changed their mind. So if you want to talk through these issues, reach out, take a look at the website, frankbrunolaw.com.